Institute for Law and Liberty. Today I'm going to give you two quick litigation updates. The first is on a lawsuit you may have heard about, which is related to school finance, which was filed about a month ago now and is currently ongoing. And then I'll end with a really quick update on some public records law, a case that came out in August of last year that is relevant to public officials. First, on the school finance. So you may recall about 2 years ago, I think now, there was an effort brought at the Wisconsin Supreme Court. This is October of 2023, so 2.5 years ago. This was a case to challenge the state's school choice programs. It was an original action filed with the Supreme Court. The Supreme Court ultimately declined to take that case. The question was always, would it be refiled, or how would it be refiled? What would the next kind of education-related lawsuit be? That original case that was filed obviously didn't go anywhere, but the current lawsuit, which was filed about a month ago, is the Wisconsin PTA et al. Versus the Wisconsin State Assembly et al. This is a broad challenge to the Wisconsin school finance system. So the plaintiffs in the case are WEAC, which is kind of the state's largest teachers union, a couple of school districts, and then some taxpayers, parents, and students who are bringing that case. They've named as defendants lawmakers, so the State Assembly, the Joint Finance Committee in the Assembly. The last major challenge to Wisconsin's school finance system occurred about 25 years ago in the late 90s, a case called Vincent v. Voigt. In that case, the Wisconsin Supreme Court took up a challenge to the then school finance system and determined that it did not violate the Wisconsin Constitution. So it's been about 25 years since these were litigated. We've seen similar lawsuits in states around the country, so this is kind of part of a national trend where these types of suits are brought under state constitutions. And that's important here because that means that this case will end at the Wisconsin Supreme Court. It's exclusively based on the Wisconsin Constitution. There are no federal claims in this case, so the Wisconsin Constitution's last line of authority goes to the Wisconsin Supreme Court. They get the final word here. So notably though, the complaint doesn't specifically say what it's challenging. They just talk about the school finance system generally. Typically when you see a complaint, the complaint points to a particular statute, a particular program, some aspect of state law that they are specifically challenging to say this one thing is causing the harm. This complaint is more of a broad attack. It's kind of a general attack on the system as a whole. So they make 6 specific claims, and I'll just try to briefly summarize those here without hopefully putting everyone to sleep this morning. There is coffee, by the way, out there if you haven't had any. So, the Wisconsin Constitution, first of all, the Supreme Court has held that the Wisconsin Constitution guarantees what's called a right to a sound basic education. So that's a minimum, right? It's kind of the floor that every student in Wisconsin is entitled to, a sound basic education. It's kind of the absolute minimum that must be provided to every student in the state. So what the complaint argues in the first couple of claims is that that right has been violated. Their first claim asserts that Wisconsin's current public school finance system has been chronically underfunded, what they say, and the restrictive revenue limits that are imposed on districts haven't kept pace with inflation. Again, they're arguments that I'm summarizing. And since the repeal of automatic adjustments to revenue limits, it denies every student an equal opportunity to a sound basic education required in the Constitution. So that's the first claim. The second claim, and some of these claims are very similar and have some overlap. So the second claim argues that Wisconsin's, the legislature's finance system violates that the education provided be as nearly uniform as practicable. So the Constitution requires not only do you have a sound basic education, but that the schools that the legislature provides have to be as uniform as practicable. The education available to all the students has to be as uniform as practicable. So the second claim argues that because it's been underfunded, they're violating this uniformity guarantee. The third claim relates to what they call high needs students, so special needs students, and argues that this constitutional right to equal access to a sound basic education cannot be realized for those high needs students. Students with disabilities, English language learners, economically disadvantaged students is what they highlight. They basically just say that program has been so unfunded that those students themselves are also being denied the right to a sound basic education. And then the fourth claim, very similarly, alleges that the reimbursement rate specifically to special education is chronically too low. And they point to things like the private school special needs scholarship, which provides more funding as grounds for that, and they say that there's kind of these two education systems. The first four claims, those four claims were all based on Article 10, Section 3 of the Wisconsin Constitution. Again, that's the part of the Constitution that's been interpreted to require a sound basic education. The fifth claim does what we call an equal protection guarantee. So this is based on Article 1, Section 1 of the Wisconsin Constitution, which really mirrors the federal 14th Amendment's equal protection guarantee, but it's Wisconsin's version of that. They say that the current school finance system violates equal protection because it deprives those high-need students of an equal opportunity for a sound basic education. The final claim is some very novel claim. It's Article 1, Section 22 of the Wisconsin Constitution has what's called the Free Government Clause. It says the blessings of a free government can only be maintained by a firm adherence to justice, moderation, temperance, frugality, and virtue, and by frequent recurrence to fundamental principles. So that was a line that's been included in our Constitution since statehood. It's always been interpreted as sort of an aspirational line, not conveying any sort of individual rights. But these plaintiffs are trying to essentially make that something that's justiciable, that they can say, you violate that free government guarantee. The argument, presumably, is that these students are being denied the blessings of a free government and that we need to return to fundamental principles. I don't know what the court will do with that claim. Those six claims, then, are now before the court. This was filed in Eau Claire County Circuit Court. I believe the Eau Claire School District is one of the plaintiffs in the case, so that's why it was filed up there. Currently in Eau Claire County, whereas the last case was filed directly with the Supreme Court as an original action, this goes to the circuit court, the trial court level. What they're asking for the court to do here is to declare the current school finance system, again, kind of amorphously, don't know what that means, unconstitutional, and then to basically throw it to the legislature to fix it. And then they say if the legislature doesn't fix it, or they don't fix it enough, then they want the court to impose its own remedy, its own school finance system that the court would then order to apply statewide. So there's a lot of unknowns and uncertainties here. When we get questions about this, we don't know exactly what the system could look like because we don't really know what they're challenging or at the end of the day what the remedy would be, what the legislature will look like when this comes out. So this case was filed. The defendants are represented by partisan affiliation, so there are Democratic lawmakers represented by one group of lawyers. The Republican lawmakers were represented by a second group of lawyers. The Democratic lawmakers filed an answer in which they largely agreed with the lawsuit and said, yeah, you know, we're not really, they sort of indicated they weren't going to fight it. I can't speak for them, obviously. The Republican lawmakers filed what's called a motion to dismiss. That motion to dismiss is now pending. We represent a group of choice schools who are trying to intervene in this lawsuit, as well as parents who are trying to intervene in this lawsuit. What to expect here, as I said, the case was filed in Eau Claire County Circuit Court. That motion to dismiss is pending, as well as a couple of intervention motions. The court hasn't done anything with it yet. I think the first step that they're going to have to do is they're going to have to deal with that motion to dismiss and those intervention motions, decide who's in the case and whether the case moves forward. They could dismiss the case outright, grant the motion to dismiss, in which case I'm sure the plaintiffs would then appeal that. It would go to the Court of Appeals and then ultimately the Wisconsin Supreme Court. If they don't grant the motion to dismiss, then we're at the trial court level. That case moves forward. There's probably going to be a trial. They make a number of factual allegations in their complaint related to school finance and just the revenue limits and everything that are going to have to go to a jury to decide what the facts of this case are. Once the facts of this case have been established by a jury, then the court will issue a legal ruling, and that's going to be appealed then. I'm guessing this whole case is probably going to take 3 to 4 years is kind of the timeline that I'd be operating under. There are any number of things throughout this that could speed that up or slow it down, of course. In other states, we've seen this take a significant amount of time just because these are very heavy legal issues that require a lot of litigating and a lot of lawyers, so, which is not what anybody wants to hear, I'm sure. So that case is, what is the implications? What does it mean for school districts? For right now, it's just kind of status quo. I think the law is the law, and you kind of continue operating until there's some change. It could mean significant changes in the future. I don't know exactly where it's going to go. The school finance formula could change significantly in terms of how the state aids your school districts or your school if you're a charter. So that's out there. Also then, in the background of all this is the Act 10 case. The Act 10 case that's currently ongoing, if you recall, a Dane County Circuit Court issued a declaratory judgment that Act 10 was unconstitutional, that it violated what's called rational basis review. That has been appealed. That appeal is fully briefed. It's before District 2 Court of Appeals, and it's been there now for, I want to say, almost a year. It's been fully briefed and pending there, so we do expect a decision in the not-too-distant future. The Court of Appeals does take a very long time to issue decisions here in Wisconsin. If anybody's ever familiar with the court system, there are 4 appellate districts in Wisconsin. There are mandatory appeals, so they have to hear every single appeal that gets filed. As a result, it usually takes about a year to get your appeal decision. And this one will be, I'm sure, a very lengthy decision. So that case and whether Act 10 is legal or not, the Dane County Court did stay its decision, so Act 10 is still in force right now. Depending on what the Court of Appeals does, there will almost surely then be a petition for review filed with the Wisconsin Supreme Court. And then that case is probably, I would think, maybe about a year out from having a final decision from the Wisconsin Supreme Court on that particular Act 10 challenge. So that's the legal side of it. Obviously, with the elections this fall, if things change, there could be underlying statutory changes that moot some of that. But those are kind of the main, school finance-related lawsuits that are out there right now. And we'll be taking some questions at the end of this, so I'd be happy to answer any then. But the last update I want to leave you with from a litigation standpoint is regarding public records. So there was a case last August called Midwest Environmental Advocates versus Preen. The background on the case is pretty simple. Frederick Preen was the chair of the Natural Resources Board. His term expired in 2021. Under Wisconsin law, if you are an appointee who's confirmed by the Senate, you can continue to hold over in that position until your successor has been confirmed by the Senate. So his successor was never confirmed, so he just kind of stayed in office and continued to do this job at the time. Midwest Environmental Advocates submitted a public records request to Mr. Preen. Mr. Preen didn't turn over the records that Midwest Environmental Advocates thought he had, so they filed a lawsuit. The lawsuit, what the court did was they ordered a forensic review of Mr. Preen's devices, including his personal cell phone, which revealed 126 text messages that they determined were relevant to his work and were records under the state law that he had to turn over. And then they awarded attorney fees to Midwest Environmental Advocates. So I think the kind of 2 big takeaways from that case that are probably relevant to everybody here that I like to remind all public officials on are that 1, public records requests include your personal cell phone and personal text messages. It's the content of the message itself that matters. Your email address, personal emails, those can all be subject to public records law. It's the content of the message that matters. If it relates to your duties as a public official, it is very likely a public record. It doesn't matter the device or the account or who owns it. It's the content of the message that makes that determination, and that's what the court confirmed here. And this is a Court of Appeals decision that was not sent to the Supreme Court. And then second, they sort of recreated a little bit of a financial incentive to litigants to bring these type of lawsuits. So there was a case a couple of years ago called Friends of Frame Park, in which the Supreme Court made it more difficult to obtain attorney fees in public records cases. It was, in my opinion, a very tough case for public records law. It made it more difficult for people to bring these suits, right? We, as an organization, obviously bring these lawsuits because we're a nonprofit that's funded to do this, but a lot of attorneys won't bring them because you have to pay for them. And if you can't recover your fees on the back end, it makes it really difficult to hire an attorney, or you're going to have to pay thousands of dollars to an attorney to bring these cases. Friends of Frame Park made it harder to recover your attorney fees. This case said that no, any action by the court that sort of spurs those records to be released. In this case, after the forensic review revealed 126 messages, Preen then turned those messages over. So he said, well, the case is now moot. I turned the records over. There's no more outstanding records. The case is dismissed. Midwest Environmental Advocate said, yes, the case is dismissed, but he only turned the records over because the court discovered these as part of the legal process, therefore you owe us attorney fees. The court agreed with that. They got their attorney fees on it. So there's a lot of legalese there, but the key takeaway is that what I expect to happen is more of an influx in public records lawsuits going forward, kind of using this theory to obtain fees. Probably more attorneys who, as this gets out, are going to be more interested in taking these types of cases. So just a good reminder to be diligent on public records. It's a key and important part of our state law to pay attention to, and that is my full update today, and I'm turning it over to my colleague, Dan Lennington. Thank you.
Good morning. I'm going to give you a little bit of update on some race issues that are going on right now. around the country, and then we'll talk about parental rights. So why am I talking about race? Race is never permitted to be used in education, public, private education. It is still going on, though. I've yet to find a school or school district that isn't using race in some way still. The Constitution does not permit any distinctions in public education based on race. And federal law under Title VI, if you receive federal money, you're also bound by that. You could lose all your federal funds if you use race. So what is prohibited is race discrimination. And I have sort of 7 rules on race discrimination that I like to share. I also teach at UW Law School, and these are the 7 rules I give to my students when we talk about race discrimination. So, number 1, race discrimination doesn't just mean treating somebody poorly based on race. It could mean treating someone favorably because of race, which is a lot what we see right now with DEI. Even if race is sort of a tiny factor in a decision, that's unlawful, illegal, unconstitutional. And by the way, there is a 1-pager on race that you guys will be able to have, and so all these rules are in here. Number 2, diversity is not a lawful reason to discriminate based on race. This would also include hiring teachers because there be role models for your minority students. That's been unconstitutional for 40 years. School districts can't do that. They can't use race as a factor to hire teachers, promote teachers, move people around, diversity of boards, teams, committees, hiring committees. Race can't play a factor in any of that. It's all unconstitutional and illegal. 3, policies that have the purpose or effect of racial balancing. So a lot of school districts will do this when they sort of redraw lines from schools. They did this in Sun Prairie about 4 years ago. They literally drew lines saying we want more minorities in this school and less minorities in this school. Completely unconstitutional, illegal. You'll go to court, you'll lose, risk all your federal funding. School districts do it anyway. Race can't be used as a way to sort of cure historical discrimination, societal discrimination. That's all illegal. Even number 5, racial categories themselves, the Supreme Court said 3 years ago. The big 5, white, black, Hispanic, Asian, Native American, those categories in and of themselves are probably unconstitutional, arbitrary, under-inclusive, over-inclusive, irrational, the U.S. Supreme Court said. Be careful when you're using any racial categories for any reason. And the last 2, race can never be a negative for someone, and race can never be a stereotype. For example, Harvard used to say, a black student can bring something to the classroom that a white student cannot. That is an unlawful and unconstitutional stereotype. So those are sort of the 7 rules that I use when I tell people about what is race discrimination, what's illegal, what is unconstitutional. So what are the hot issues right now? The U.S. Department of Education has been downsizing, rapidly downsizing. Their ability to enforce the non-discrimination laws, Title VI, is diminishing greatly. It doesn't mean you don't have to follow Title VI. It just means that if there are problems that are being brought to U.S. Department of Education, you're probably not going to hear much about it. We've got several cases pending with the U.S. Department of Education, and we're just not hearing anything about them, even though they're egregious examples of discrimination or violation of rights of girls. Guidance on race-neutral school discipline policies are in effect. So last year, President Trump revoked the race-conscious discipline policy of the Biden and Obama administration. Race not supposed to play any role in discipline anymore, so you're not supposed to disaggregate your data and see, like, are blacks suffering worse because of this discipline policy than whites? Can't do that anymore. There are still 2 executive orders that are still in effect right now on ending federal funding for DEI policies, which would include DEI policies that go and fund curriculum or training at your schools, and other programs. What we're seeing to get around sort of this new federal interest in getting rid of DEI in our public schools are code words that we're seeing develop. And these code words have been around. Some of them have been around for a while, but we're seeing more and more and more. So just if you're a school board member, you hear an administrator tell you things like, Diversity, equity, inclusion, any of those words should set off alarm bells. You should be asking questions. What do those mean? Implicit bias, culturally relevant, whiteness. If somebody says whiteness, please call me. That's a bad one. That's a no-no. Whiteness, always going to be a bad one. Other phrases you probably hear all the time you think there's nothing wrong with, but they're typically used as code words for race, like disadvantaged, underrepresented, marginalized, historically excluded, decolonizing. We're going to decolonize our library. All these sort of things are out there. Be careful when you hear them, because the person telling you them is probably using race as a factor in their decision making. Also, explosion of acronyms. You've all probably heard BIPOC, but we've got ADOS, we've got ERSOC, we've got BAME, we've got PEERS, we've got HUGS, we've got MENA. All these things, you should look them up. ERSOC was one I discovered that University of Wisconsin uses. Underrepresented students of color is an ERSOC. They didn't want to say black anymore, so they said ERSOC. And by the way, some of these discriminate against Asians, some of them discriminate against Hispanics, some of them discriminate against blacks. I've seen scholarships that are for whites only at the University of Wisconsin. So it's all about racial balancing, trying to get the right mix, trying to get the right racial composition of a class or whatever. That's all unconstitutional. You could be liable, your teachers could be liable, your school district could lose money. These are hot stoves. You don't want to touch them. There's liability concerns that I'm seeing around for districts. Advertising or offering scholarships on your website based on race. See this all the time. Even if a third party is doing it and you're just letting your students know about this race-based scholarship, that liability could be imputed to you. Hosting clubs or affinity groups based on race, that's a really risky proposition. Teachers or administrators disaggregating data and taking actions based on race. I've heard of teachers being told they should disaggregate data at the end of each day to determine whether they were calling on white students more than black students. Segregated meetings, segregated field trips. I've seen segregated field trips. I've seen all the black kids put on one bus and all the white kids put on another bus. Happened just a few years ago. Stereotyping privilege, stereotyping disadvantaged. Tutoring, counseling, or special programs targeting certain racial groups. Unconstitutional. They do that in Sun Prairie right now. They have special tutoring just for black kids. Unconstitutional. There are some cases pending, just briefly, that are, kind of big news nationwide and around here. One is called Henderson. It's in Missouri. It's about a DEI training session that the teachers are saying it constituted racial harassment and compelled speech. That case was allowed to move forward. Callie Bishop versus Madison Metropolitan School District. Callie Bishop was a longtime counselor, a very highly rated counselor. They downsized the counselors in Madison, and they downsized her, claiming that she was not, quote, culturally responsive, which was just a code word for she was white. There is a case pending in Hartford, Connecticut about a teacher alleging retaliation after complaining about anti-white training. The U.S. Department of Justice has sued Minneapolis School District recently about hiring and transfer policies based on race. There are racial balancing cases pending in charter schools and choice schools in Pennsylvania, Massachusetts, Virginia, and New York, which are about charter schools that were too Asian or too white. And school board members literally said, this school's too Asian, we have to make it less Asian. And so they want to change all the criteria for like zip codes and use all these racial proxies to like balance out the district and then say, we're not actually using race, we're using zip codes. That's fine. That's not fine. That's not fine. And then also racial funding. We have a complaint pending against Jefferson County, Kentucky, where they literally have per pupil funding based on race. So black kids get more money per pupil than white kids. That's race. I hope none of that's surprising to anybody. Usually half the room is completely surprised and the other half is not surprised. The last two things I want to talk about are parental rights. A year ago, June, is the anniversary of Mahmoud versus Taylor. This is a, huge U.S. Supreme Court decision. In that case, Maryland, a school district had a curriculum that included LGBTQ books for K through 5. Parents objected, and the school district said, I don't care that you object. Parents couldn't opt out. The U.S. Supreme Court said this violates the First Amendment rights of the parents. The right to direct the religious upbringing of your children was the holding in Mahmoud, and that you have a right to notice and opt out. So here's some questions about how far Mahmoud goes. How far does the right to opt out go? Does it extend beyond sort of transgender books or sexually explicit books? Does it apply to non-religious parents? That was answered pretty recently. And is notice actually required? Do you have to notify parents, or is this just a right to opt out? Those are some open questions. The takeaway from Mahmoud is the safest thing to do is allow broad opt-outs for parents. When a parent is objecting to something, allow them to opt out. Most parents won't opt out of basically any curriculum, but controversial things are likely to be opted out, so just don't include controversial things in your curriculum. Give very liberal notice to parents for topics that you think might be controversial or potentially controversial. So Mahmoud is the right to opt out. Now Mirabelli was on March 2nd, and that's almost the latest, biggest case, Mirabelli. California had a statewide secret gender policy. These are the policies in which teachers allow children to change gender at school, names, pronouns, clothes, bathrooms, and then they don't tell the parents. There are, I think, 40 cases pending nationwide. We brought cases against Madison, Kettle Moraine, Eau Claire. We've helped in many other cases. There's thousands of these policies nationwide. There are three districts right now, at least, that have public secret gender policies in Wisconsin. Menominee area, Milwaukee, and Eau Claire are the three that still have them up on their website. The Supreme Court said that these policies likely violate the First and the 14th Amendments to the U.S. Constitution, that they violate the parents' right to direct the upbringing of their children. It applies even in the non-religious context. So Mahmoud has been expanded to mean you have the right to direct the upbringing of your children, includes not only the right to opt out of curriculum, but also the right to know if your child is going through a secret gender transition at school. This is a broad endorsement of parental rights. There is one case pending at the U.S. Supreme Court called Littlejohn. It was about a 13-year-old girl who was given a new name, pronouns in schools at her school in Florida, and the parents sued the school district. That one has been completely litigated at the lower court, went through the Court of Appeals, and it's now at the U.S. Supreme Court. So the idea that Mirabelli is just a very limited case is probably going to be borne out pretty quickly by this Littlejohn case, which will be on the merits and will be not a preliminary decision, but a final decision. Takeaways from Mirabelli: you have to require parental notice and consent for name and pronoun changes. You have to be monitoring your teachers and make sure they're not doing this. Teachers should not be having their own classroom policies, or principals should not have their own building policies, allowing new names, new pronouns, new bathrooms, secret gender transition closets where kids come to school and they change their clothes and don't tell their parents. Those things all go on. This applies to bathrooms. That's relatively simple to sort of fix this Mirabelli issue. We do this for medication, we do this for field trips. We offer parents the right, the notice of what's going on with their kid, and we offer them a right to opt out. And so the last thing I want to say is that last night, the Third Circuit ruled that parents could file these claims and seek damages for them. So they could get damages against the school board, school employees. So that's where all these race and parental rights cases end up, is lawsuits against school administrators, school board members, for money. And yeah, maybe you're covered by your insurance policy, but at the end of the day, the taxpayers are probably going to have to pay for this, and they're not going to be super happy when they're paying for big bills. So these are real consequences, not only for the parents whose rights are violated, but also for school board members and administrators who could be liable for these actions.
Okay, thank you, Dan. Thank you, Lucas. So that's a lot of legal information, and there's more to come. You learned about the recent school funding lawsuit, open records, Act 10, race in the law, parental rights. Now I get to talk to you about a few Title IX updates and the federal scholarship tax credit. So first, we're going to turn to Title IX, and this could probably be its own presentation, but I'm going to try to give you some highlights on things that I think you should know. So a lot of you already know about Title IX. Obviously, this is the federal law passed by Congress in 1972 to make sure that schools receiving federal funding do not discriminate or treat people differently based on sex. Now, one of the cases that I want to point out for you is currently at the United States Supreme Court. This is West Virginia versus BPJ. Like I said, it's currently pending. Oral arguments already occurred. We are expecting a decision in this case by this summer, likely the end of June. And what prompted this lawsuit was a West Virginia law that limits sports based on biological sex. This occurred, like I said, out of West Virginia, and at first, when it went up on appeal, the Fourth Circuit held that that violates Title IX. You can't separate sports based on biological sex, and it could also violate the Equal Protection Clause. Now, like I said, oral arguments occurred at the United States Supreme Court, and oftentimes you can kind of tell from the justices questioning what way you think this one might go, and most attorneys that I've talked to are pretty clear that the United States Supreme Court will held, no, it doesn't violate Title IX. So again, you never exactly know what we'll get from SCOTUS, but I think likely this summer we will see a ruling on sports and can biological males play on girls' teams. The question here is actually, may states pass a law that prohibits biological males from participating on girls' teams? So this, in terms of takeaways, could be very significant. There's another issue that's different but related, and it is that of bathrooms. So same legal analysis in large part when it comes to Title IX, but very similar rationale. Will actually filed an amicus brief in this West Virginia versus BPJ sports case to address the bathroom issue directly. It's not likely that the court will address bathrooms in its decision, but they could. So it will, at the very least, resolve that sports issue. And like I said, it's very important to note the distinction of may states and school districts separate sex by sports by sex, and must they. Those are two different questions. In the BPJ case, it's the may question. Schools may schools separate sports based on sex, not that they have to. The must question is being litigated elsewhere as well by the Trump administration and others. I think it's reasonable, safe thing to do, limit sports based on biological sex. There's also a WIAA rule that was updated after some of the Trump executive orders that helps with this. It aligns with what President Trump has laid out in his executive order. The language in the WIAA rule is that a student athlete whose sex assigned at birth is male, so a biological male, may not compete in a WIAA girls sport. My understanding is they're allowed to practice, but may not compete. So that's kind of the overview, high-level overview of the sports issue when it comes to Title IX. The next thing I want to turn to is related, and it is on the issue of bathrooms. This is a case called AC versus Metropolitan School District of Martinsville. We refer to it as the Martinsville case. So this is out of the Seventh Circuit, which is where we are. Wisconsin, Illinois, Indiana. This case arose in Indiana. It involved a transgender middle school student, AC, who challenged a school policy requiring restroom use based on biological sex. The claims were brought again under Title IX and the Equal Protection Clause, and the district court granted a preliminary injunction, which is essentially something very early on in the litigation in which AC was asking, hey, as this litigation proceeds, can I use the opposite sex bathroom? And the court said, yes, you may. And the Seventh Circuit affirmed that, holding AC was likely to succeed on the merits and treating that policy as sex discrimination. So a lot of you have heard and maybe even talked to us directly about the case here out of Kenosha called Whitaker. This AC versus Martinsville case is going to directly address that bathroom issue and will answer whether Whitaker has been overruled. And I'll get to that shortly, why we think that's likely to happen. The school district filed a petition for certiorari, which is a petition to the United States Supreme Court to resolve a circuit split, because the 11th Circuit on the exact same issue came to the exact opposite conclusion. So we have a circuit split here, and eventually we think the United States Supreme Court is going to have to weigh in. Back in January 2024, the United States Supreme Court denied that petition, so they didn't take the case, and they didn't comment. We don't know why. So I think the likely holding is going to be that Whitaker case will eventually be overruled. It will be gone. Timing is to be determined. It's going to be for sure after the BPJ case, but could be well into the fall or even next year. Takeaways in terms of the AC versus Martinsville case. It will most likely hold that Whitaker versus Kenosha County is overruled. Why do I say this? The Seventh Circuit has already invited briefing, so submissions from the parties, unprompted, on whether to reconsider both Whitaker and AC in light of Scrimeti. That was the recent case on whether states may prohibit child gender transitions medically. So, what does that mean? We know the court is at least open to revisiting this entire line of precedent. Again, this is a may versus must question. If Whitaker is overruled, it will be a may. Schools may separate bathrooms by sex, not must. However, that brings us to the case that Will recently filed against the school district of New Richmond. We filed it about a week ago in federal court. We represent a parent association called New Richmond Parents for Strong Schools. It actually includes both parents and students. That case, our case, argues that allowing boys to use the girls' restrooms and locker rooms violates Title IX. So here we're going from may to must, the question that they must be separated. The Trump administration is also taking this position in various lawsuits, enforcement actions, and investigations, including one against New Richmond. The Trump administration Office for Civil Rights actually opened an investigation in New Richmond shortly before we filed our lawsuit. So just briefly, I'm sure many of you have followed the case. It's been getting a lot of attention online, on social media, in the media. However, just a brief overview, parents became aware that the school had a policy that allowed students to use whatever bathroom aligns with their gender identity. They were surprised to hear this in rural New Richmond. And not only did the school have the policy, but an upperclassman male student was using the girls' bathroom. And not only that, but a number of girls complained about this to their administrators. They went and talked to the principal. Their parents sent messages to the superintendent and principal, and they said, hey, this doesn't really make sense. Why is it that one student gets to come in and use our bathroom, and how do we actually know that the student is transgender? What's the metric that you're using to know that it's not just a boy using the girls' bathroom? Valid questions. And the district legitimately just told the girls, this is the law, we can't do anything about it. If you're uncomfortable, then you use the single-stall bathrooms across the school. They even posted maps of where the single-stall bathrooms were. And a lot of the girls were saying, hey, okay, because I don't want to use the bathroom with this boy, but I'm going to miss class. I have to miss lunchtime. And the principal, assistant principal would say, well, we'll excuse your tardy. Just let us know if you need it out. Well, we don't think the girls should have to miss lunchtime, have to miss class time. Some of them actually aren't going to the bathroom at all during the day. Some of their parents said, hey, we live close to the school. Why don't you just come home to use the bathroom? Others go use the single stall. Sometimes there's a wait. Sometimes there's a line. And then others have honestly, most recently, been made to feel that you're hateful. If you don't use the girls' bathroom because of this, you're really hateful, and how dare you feel that way? So many of them, unfortunately, are still using the girls' bathroom, and we heard just the other day that a male went in and out of the girls' bathroom. So that's what's happening in New Richmond. The school board introduced a policy, actually Will's model policy, but it didn't go anywhere, so this policy is still on the books. And takeaways here for you all. There is litigation risk on both sides. This is a hard decision. It's a decision you have to make, though. I think certain legal counsel are telling school districts that Whitaker is the law, Whitaker is president, you must do what Whitaker says. There is litigation risk on both sides, and that's a decision that you have to talk to your legal counsel about, do the research, decide how you want to handle this issue. We think the safer course right now is to limit bathrooms by biological sex. And although Whitaker is technically still on the books, we think it was wrongly decided, and it could be overruled soon. And it feels silly to say this, but I'm going to say it anyways. Of course, provide transgender students with the safest, most accommodating, neutral alternative you can. We want to have respect and dignity for every student while also protecting the girls' spaces. And for those multi-person facilities, like the girls' room, like the boys' rooms, limit them by biological sex. So I know there could be a lot of questions there. I'm going to move on to our last topic, and I'm going to give an overview of the federal scholarship tax credit. How many of you have heard of this opportunity? Okay. And after I'm done, I'm going to invite Superintendent Joe Garza to come up and give kind of a on-the-ground perspective of how this opportunity could benefit kids in not just private schools, but public schools as well. So there is a handout, front and back one-pager, that will include everything that I'm about to say. Will also released a report called Unleashing Opportunity. So I've read this federal scholarship tax credit comes from the One Big Beautiful Bill. I've read this section of the One Big Beautiful Bill many, many times, and we include the citations in that Unleashing Opportunity report if anyone's interested in going back and finding the details. But what is this opportunity? What's the bottom line? It is a new federal scholarship program that allows private donations, not taxpayer funding, no cost to the state, private donations to support students in all school settings, including public schools. And if Wisconsin opts in, because the way the bill is drafted, the governor from each state has to opt the state in for the kids to be able to get the benefit, this creates a new stream of resources that can directly benefit the students in your district. So under federal law, individuals can receive a 100% federal tax credit of up to $1,700 annually. So donors, you can donate more than that if you want to, but if you donate at least $1,700, you will get a tax credit of all of that back, dollar for dollar tax credit to lessen your tax liability. And that is if you donate to a scholarship granting organization, or SGO. The SGOs then distribute the scholarships to eligible K-12 students. Who's eligible? It is students in families of up to 300% of the area median income. What can the scholarships be used for? What the One Big Beautiful does is it cross-references something called the Coverdell Savings Act, and that includes all of the eligible expenses. Families can use these scholarships for tutoring, supplementary curriculum, supplies, transportation, technology, internet, special education services, therapies, and more. Importantly, because I've seen a lot of mischaracterization in the media, this is not a voucher. It's not a voucher. It does not reduce school districts' funding at all. It does not cost the state anything. It is privately funded through these federal tax incentives. So I would encourage you to kind of look at that one pager about how districts can more specifically make use of this program if Wisconsin were to opt in. Specialized services, supplemental supports for students with IEPs, before school care, after school care, transportation, things like summer learning programs, supplemental curriculum, coursework. There's so many opportunities. It's such an exciting thing. I think over half of the states have opted in already. At least one Democrat governor, Jared Polis out of Colorado, has opted in. There might be even more now. There's certainly more that have indicated a willingness to do so. But what needs to happen in order for Wisconsin students to access these resources, the state must formally opt in to the federal program, and that, for us, that would be through Governor Evers. From there, scholarship granting organizations must be established so they can begin receiving donations and distributing scholarships to students. The federal agency in charge of implementing this is the IRS, or the Department of the Treasury, Department of the Treasury, and they're still finalizing the implementation of the rules, and that will guide the details of how this program will operate. If Wisconsin doesn't opt in, and Governor has already indicated that he will not opt the state in, the program still moves forward nationally. Wisconsin taxpayers can still make donations. Wisconsin taxpayers can still get that $1,700 tax credit. But those dollars are then going to flow to SGOs in other states that have opted in, and they can't come back to Wisconsin students. The SGO has to donate to students in a state that has opted in. So that means we can still get the tax credit. However, Wisconsin students and families will never benefit from these additional resources. So with that, I would invite Superintendent Joe Garza to come up and just give a few more details about the program and how he thinks it can be beneficial.
So a recent article that I came across states, Wisconsin governor rejects bill to join Trump's private school voucher program. Very misleading. And what I would say is there are three things that I want to touch on. Number one, academic tutoring is something that can be used with these funds. Academic tutoring has a backing from research, and feel free to ask Dr. Cade Brumley from Louisiana, who is a keynote speaker today, about the positive effects that tutoring has had on student learning based on said tutoring. Did you know that public schools are eligible to receive these dollars? They are. Number two, the Wisconsin legislature and the governor's office at this moment are currently negotiating over what to do with the overtaxing we've experienced in Wisconsin, and those tax dollars are now sitting in the state's coffers. One key item in the negotiation is about providing dollars to school districts to support the partially unfunded mandate of special education, as well as providing tax relief. Did you know that public schools may be eligible to receive these dollars? We are. Transportation. Talked to our CFO last night. It's one of our biggest line items in costs in our school district. That is possibly eligible as well to use these dollars with. While we don't know the current details about what this means for reimbursement, we certainly do know that these dollars are available for public schools. The devil certainly is in the details, but our great state of Wisconsin should not officially opt out of these financial possibilities at this time, especially when the federal legislation is in the public comment phase. As a practitioner, I'm not an attorney. I would encourage you to do and make note of the following. Learn more about this legislation. Unfortunately, not too many people know about it, especially in the public school sector. 2, stay up to date regarding this legislation. reach out to Will. They've been a great resource for me. And then finally, advocate through action and do not sit idle as it relates to this legislation if you feel it may benefit your school district. Thank you.